Under Section 68 Evidence Act, proof of execution of a document required by law to be attested. In a case of Virappa versus Ramaswamy, 1907, 30 Madras 251, it was held that this section applies to cases where an instrument required by law to be attested bears the necessary attestation. What the section prohibits is a proof of execution of a document otherwise than by evidence of an attesting witnesses if available. In the case of Radha Mohan versus Haribandhu, AIR 1991, NOC 109, it was held that this section applies only where the execution of a document has to be proved or when the allegation is that the executant was not in a fit state of mind to know the real nature of the document. In the case of Komal Singh versus Krishnabai, 1945, 48 Bombay Law Reports 83, it was held that where, however, the execution is not to be proved, it is not necessary to call any attesting witnesses unless it expressly contended that the attesting witnesses has not witnessed the execution of the document. In the case of Wigmore, section 1304, it was held that the object of placing a more attestation than one upon a document, whether at the party's voluntary instance or by requirement of the law, is ordinarily not to demand the combined testimony of all at the trial, but merely to provide, by way of cautions, a number of witnesses, so that contingency of a death, removal of residence, and like may be guarded against, and one witness at least may be available. But the main object in a statute requiring attestation as an element of validity is to be surround the act of execution with certain safeguards. The object of securing evidence for litigation is a secondary one. In the case of Dashrath Prasad versus Lalu Singh, 1951, Nagpur 873, it was held that mere general denial of mortgage or not admitting it cannot be regarded as a specific denial of its execution within the meaning of the proviso to this section. When there is only a general denial of execution and there is no cross-examination regarding attestation of a witness who comes forward to swear the execution, then it can be presumed that there was due attestation. In a case of Vishnu Krishnan versus Nathu Vittal, 51 Bombay Law Reports 245, it was held that this section is not permissive or enabling. It lays down the necessary requirements which the court has to observe in order that the document can be held to be proved. The principle underlying the section is that execution of the will must be proved by at least one attesting witnesses. That is, that it is only an attesting witness who is entitled to prove the execution of the will. It is concession that the legislature had made. If that concession does not result in complying with the mandatory requirement of this section, the only proper method is to call other attesting witnesses so that both the attesting witnesses are before the court and the due execution of the will is proved by two attesting witnesses which are necessary before a will can become a valid document. In a case of K.M. Varghese versus K.M. Oman, AIR 1994, Karnataka 85. Dissenting from Roj versus Kanta, AIR 1946, Bombay 12. It was held that to prove a will, it is not necessary that the attesting witness should depose that the other attesting witness had signed the will in the presence of the testator, and after seeing the testator signing the will, as both the attesting witnesses need not be present at the same time. Under section 69, prove where no attesting witness is found. In a case of Musmat Shahjmadi Begum versus Sood Qasim 7, Patna 312, it was held that in this case the effect of the proviso to section 68 was not brought to the notice of the court, and attesting witnesses, if available, should be called in evidence. If the attesting witness is dead or is living out of the jurisdiction of the court or cannot be found after diligent search. In a case of C.G. Ravindran versus C.G. Gopi, AIR 2015, Karnataka 250, it was held that if the document purports to have been executed in the UK of Great Britain and Ireland, two things must be proved: the signature of one attesting witnesses and the signature of the executant. Section 69 applies when no attesting witness is found. In absence of any other provision dealing with the cases wherein the presence of witnesses cannot be procured for various other reasons, like death of both the attesting witnesses, out of jurisdiction, physical incapacity, insanity, etc., this section should apply. In a case of C.G. Ravindran versus C.G. Gopi, AIR 2015, Karnataka 250, it was held that section 69 imposes twofold duty on a propounder. It provides that if no such attesting witnesses can be found, it must be proved that attestation of one attesting witnesses at least is in his handwriting, and also that the signature of the person executing the document is in the handwriting of that person. Both these will have to be cumulatively proved by the propounder. Evidently, the section demands proof of execution in addition to attestation and does not permit execution to be inferred from the proof of attestation. However, section 69 presumes that one of the handwriting of the attesting witnesses is proved. He was witness the execution of the document. The provings have to be in accordance with the section 67 of the Act. In a case of Uttam Singh versus Hukam Singh, 39, Allahabad 112, it was held that where the executant of and all marginal witnesses to a mortgage deed were dead, it was held that the mortgage deed was sufficiently proved by evidence that the signature of the mortgagor was in his handwriting and that the signature of the two of the marginal witnesses were in their handwriting. In a case of Gidamma versus Venkatama, AIR 2010, NOC 626, it was held that where no attesting witnesses of a will could be found, the court said that there must be proof of the signature of the scribe would not be sufficient. In a case of Sylvie George versus Anna Joseph, 2014 AIR CC 2515. It was held that where none of the attesting witnesses is alive, the will can be proved by a person who is acquainted with the signature or handwriting of any attesting witnesses by giving evidence that the signature in the will is that of the attesting witnesses as was done in the instant case.